Yes, ma'am. Okay.
Please check on High Court tomorrow list.
Date given matter for 25th.
My lords, matter pertains to KPADFP. Lords, I directed the matter to be listed on 18. I request for 25th, my lord.
Any mentioning? List one, page one,
23.
so number 1 and 2. Page 2, 3 and 4, 3 to 5. Page 3, 6 to 10. Page 4, 11 to 14. Page 5, 15 and 16. Page 7, 17 and 18. Page 8, 19 and 20. Page 9, 21. Page 10, 22 to 24.
My lord, serial number 23, my lord. Matter was for reporting settlement. I am for R1 and R2. A matter is arising out of a partition suit, my lord. Only one property, there is some small minor this thing. If another 2 weeks time, we will settle it off, my lord. I've informed the,
You've
informed, yes, my lord.
It
I've
is
informed.
submitted by the learned counsel for the appellant that a short accommodation is required for recording the settlement as stated on the last date of posting. List after 2 weeks.
2 weeks, yes, my lord. Obliged.
Page 11, 25 to 29.
Lord, serial number 26. We are yet to receive paper books in this matter. I appear for R2. A request for 2 weeks time. Final hearing, ma'am.
Final hearing matter. Have you informed the other side?
Hearing for appellate.
No objection.
They may be directed to serve me a copy of the paper book as well.
Joint request. List after
2 weeks. Any date.
16, 4. Serial number 29. 17, 4.
yes.
Serial? I am for appellant.
Yes.
Serial number 29.
Small matter. Who appears against you?
I am for appellant.
Who appears against you?
Ranganath.
Have you informed the other side? Please inform the other side and then inform the
Contesting
court.
respondent.
Page 12, 30 to 32.
Not the government advocate, there are private.
One more private.
Yes, please inform and then. Yes,
List one, admission, seal number 1, Sumana Naganan.
yes. Solar power panels. Matter can be heard.
Lord, matter was admitted, my lord, on 7/2/2022.
Mm.
It's to be heard, my lord, finally.
It is already admitted, then why
Yes.
it's coming up for admission for hearing? Can we pass it over and hear it today?
Yes, my lord. Only thing is 2:30, my lord, there are a couple of matters.
2:30, there are a couple of other benches also.
Before
Other,
Before 2:30, na?
before 2:30, if both of you are,
Very well. We'll try, my lord. Only thing is.
will it take some time?
Yes, my lord, it will take some time. In the sense.
Let's have it on some other day. Then we'll have it on some other day. Give a date.
15th April.
It is submitted that the appeals are admitted. List the. Oh, specifically for admission so that
Yes.
it would be heard.
It will
the
reach.
appeals. So if you can agree on a date, we can just list
It is-
this at the same stage so that can be taken up.
15th, is it?
After vacation is okay.
15th August.
Yes. 15th April. Please.
At the request, joint request,
15th,
list the matter on 15/4 at the same stage.
please.
2, government advocate.
Yes, my lord, I have sought some material instructions from my client, my lord. On 10 days time may be given, my lord.
It's a small issue. It's an outsourcing agent through, he was been appointed.
That's
Your
not
Lordship.
Small issue, Marty.
You have sought for some material instructions, my lord. 10 days time may be given.
Computer operator, food, civil supplies.
If it is material instruction, then we have to grant time.
Yes,
You have to get material instructions.
Please, my lord.
They've already been filed objections along with the documents.
Thing. You sought repeated time to show that persons who were similarly appointed along with him on contract basis had continued in service. Their specific contention is that the
That
entire services
post
of all the
itself-
persons who were appointed had been terminated.
And post itself abolished, your lordship.
And there is
That
no
is-
post.
Post.
It would be the end of it. Unless you can show something. One last chance. This is repeatedly adjourned council, nothing in it.
Please, my lord, one last.
Alternate council seeks further time. Time, 10 days time is granted as a last chance.
Much
Restore.
obliged.
Give a date.
8/4/8. 3, Venkatram CR.
Pass over.
Last time, I was directed to serve copies of this one to opposite, that is served and delivery status is also obtained. That I have to find in the.
Sugandhi Perumal.
Delivery.
We have received the copy, we will file objections. They have filed an LR application. Impleading application.
Including application, earlier one, this one, lineal descendant was there. The other 9 they have filed. In the meanwhile, we prayed for staying the order passed on 21st August 24 in another court. On the same matter, they obtained oral order from another court on 21st August 24. For that, we sought, we prayed for a stay. Stay application is
But
already.
there is no question of granting of any stay because already the amount has been withdrawn.
2023.
Here finally, no stay. Let them file objections. Then I know.
The senior counsel appearing for the respondent seeks short accommodation to file objection on IA number.
IA number,
IA 3, huh?
1 of
Yeah, 3.
24. 1 of 24.
1 of 24.
1 of 20.
25.
24 is, this is appellant.
This is the appellant Allah.
1 of 24. Yes.
Order 1 vote.
Time granted.
Hmm.
2 weeks, huh? 1 week or 2 weeks? This week.
Any.
2 weeks time. 2 weeks time granted.
4 weeks time we finally with that protection, Dharmapuri.
Yes, yes, 4 weeks time granted. After ensuing summer vacation.
4/6. Preliminary hearing, seal number 4, Muniappa Mayan,
We are for the appellant.
132 days delay.
132 days delay.
132 days.
Delay can be condoned.
Respondent.
Accepting the cost shown in the affidavit accompanied to IA number 1 of 22. The delay of 132 days filing this appeal is allowed, condoned, accordingly IA 1 of 22 is allowed. Please start.
Yes,
Ready, Diri? Ready, Diri?
ready then.
2 weeks time may be granted. I'll seek instructions from the authority. my lord.
Specific date ಕೊಟ್ಬಿಟ್ರೆ
Please.
ಭಾಳ ಭಾಳ ವರ್ಷಗಳ ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್ ಕೊಟ್ಬಿಟ್ರೆ
9/4.
9/4 ಏನಿದೆ ಅದು?
ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್
Can it be 15th minute?
The initial round you approached after 4 years.
ಆಲ್ಸೋ
It's a 4 years delay. Then
15th minute.
15.
jointly. And the request of respondent counsel.
Please.
The request of respondent counsel. They notify 15/4. Okay.
5, hearing on IA, early hearing.
Respond number 1, my lord.
Early hearing.
Early hearing filed by appellant, my lord.
Appellant,
Please, my lord.
RFA.
It was filed in the year 2022, my lord.
Hmm.
after vacation. Yes. Since the appeal is of the year 2016, IA 1 of 22 is allowed. List this appeal for hearing after vacation date.
Please, my lord.
10/6. Seal number 6, Ekdes.
Recalling.
Milord, yeah, Milord, please. I could not attend on that day court.
Delays there 176.
To oversight, it
We-
has been.
We need to secure records,
Non-compliance
Your
of
Lordship.
office objection, it was dismissed for default.
What was the office objection?
Office objection translation we have to give. Some
Data,
small
we need to
mistakes
give.
in serial numbers and all. 3 objections are there.
Yes, yes, yes. Notwithstanding the dismissal order dated 28/2024, the appellant is permitted to comply the office objection.
Within,
First comply the office objection, then we will consider.
within a week.
Yes, yes, then a week.
PF, they have to pay.
Hmm.
They can do.
Comply the office objection.
Much of.
7,
For appellant, your lordship. Respondent number 4 is the necessary party. At the time of filing of this appeal, made the PDO as a party in this appeal, my lord. Now the panchayat is merged in the town panchayat. Hence, we have made the party.
The appellant counsel submit that respond number 4 is the necessary party. The same is not seriously disputed by the AG. Hence, IA 1/24 is allowed issue. Notice,
Notice and summons may be.
issue notice to R4. Additionally, the land
Gangadhar.
counsel, additionally, land counsel for the appellant permitted to,
serve hands up.
yes, take out hand summons.
Oblige, your lordship.
Amend the constitution.
And to amend the cost rate. Cost rate amendment. And to amend the cost rate, yes,
Amend the cost title and I will file the amended petition also.
yes.
Karu ಮಾಡಿ ಇಲ್ಲಿದೆ. 8, Mukanappa SB.
This is for non-prosecution.
Still not complied.
Is already complied by after re-scrutiny, some office objection is raised. Some of
Partly complaint.
1 week time may be granted.
You comply the objection, then we will consider the IA,
Please.
notwithstanding same order of it, notwithstanding the dismissal order dated 10
It's already there. Already.
pending consideration is. Yes, you comply the office.
Much.
1 week time.
1 week's time.
1 week's, a week's time granted.
Within a week, please comply, otherwise it will stand dismissed again.
9,
My lords, appealing for appellant, my lords, sorry for appealing through VC, my lords, due to some personal inconvenience. My lords, there is a 635 days of delay, my lords. My lords, the reason is the appellant is aged about 63 years and she is depending on others, my lords, for getting all her work executed. And my lords, several documents were required to prepare this appeal, including certified copy from the LACA, my lords, tribunal order, which she was, because she is uneducated and aged lady, she was unable to secure it in the stipulated time, my lords. So kindly I request this honorable court to condone the delay, my lords.
Age is not forthcoming either in the claim petition or in the appeal memo.
So,
Age of the claim.
Is it there in the affidavit now?
yeah, please, my lords, para number 5, my lords. Of condonation of delay, para number 5, my lords.
Old age, stated that old age.
Is para 5 is.
Para 5.
Aged about 86 years. Why do you say it's 63?
So, sorry.
Your affidavit says 86.
So,
I was
sorry,
thinking that-
there might be some.
63 may not actually qualify as old age, not anymore.
My lords, but she is also uneducated, my lords, and she is depending on others, my lords. She is uneducated.
Yes, there is a delay of 693 days in filing these appeals. We have produced affidavit accompanied to the IA 1/2024, IA 1/2024. It is stated it is stated that the appellate is aged about 86 years and due to the lack of legal knowledge, she is unable to instruct her counsel to file this appeal on time. Hence, the delay is caused. Accepting the reasons assigned in the affidavit, the delay of 693 days in filing this appeal is hereby condoned. Accordingly, IA 1/2024 is allowed, subject to the condition that the appellant is not entitled for interest for the delayed period.
Much obliged. Much obliged.
List for.
Are there any other connected matters?
One Hanme Gowda is there, my lords, but that is, my lords, I will, and then I'll file a necessary application, my lords.
But this is the land acquired for the railways from
Bangalore
Bangalore
broadcast, my lords.
1 minute, please.
Bangalore to Hassan.
Huh.
This is the railways lab.
I think there are other.
Other matters,
other
my lord,
matters.
and your lordship has also considered there.
List
Yes,
along with the connected
yes.
matters.
Heard, admit, according, heard, admit, issue notice to the other respondent, according. Served, sorry,
So,
the list
upon
is
up-
appeal along with.
But I
ಅದು
don't
ನಾ MFA ನೋಡಿಬಿಡಿ ಇದೆ ಅಂತ ಕಾಣ್ಬೇಕು. Contempt
connected.
release ಅಲ್ವಾ?
They're there and some. That is what the railways say. I verified. Give the list to the court of.
ಎಷ್ಟು ಕೊಡ್ತೀರಾ?
Bangalore Hassan, we had
Yes, yes,
discussed this.
yes.
Last week we had.
Last
discussed.
week ಬಂದಿದೆ.
That the railways have informed me. I'll pass on the numbers to the court of.
Yes.
Great.
Much obliged.
10, Umesh Mulimani,
My lord, the father of
367.
counsel of respondent number 1 has recently expired, my lord. He is out of station. He is requested to have it any day next week.
Application for modified the order dated 22/6/2023, madam.
ಫಸ್ಟ್ ಡಿಲೇ ಕಂಡೂನ್ ಆಗ್ಬೇಕು. ವಾಟ್ ಇಸ್ ಡಿಲೇ ಏನು ಅಂತ ಹೇಳಿ.
My lord, I have,
367 days.
And dated 22/6/2023.
my lords, I have an instruction, my lord, with your lordship's permit, I may submit. 2023, there was an interim order, conditional order. They have not complied with in last 2 years. Even last date, my lord, your lordships had mentioned about this in the previous order, my lord. 1/8/2024 again. 50% deposit ಮಾಡಲಿಲ್ಲ. It is of the 2023 order.
Modification they can hear without the other side.
ರಿಜಿಸ್ಟ್ರಿ ಏನ್ ಇಲ್ಲಿ ಬಂದು ಕೊಡುದು? ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ ಅದನ್ನು. ಏನ್ ಇಲ್ಲಿ ಬಂದು ಅದನ್ನು ಕೊಡುದು ಏನದು? ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೊಡ್ತಾರೆ ಏನದು ಕೊಡುದು? The reason show accepting the cost shown in the affidavit accompanied to IA 1 of 2023. The delay of 367 days in filing this appeal is undone. Accordingly, IA 1 of 23 is allowed, subject to the condition that the appellate is not entitled for interest for the delayed period. Yes. Next.
Appellant is the.
Sorry, respondents. This is appellate
The appellate
corporation.
is the
then
corporation,
not
then that
required,
is
not
not
required, not required, not bad. First allowed ಅಂತ ಹಾಕಿ. List for admission. ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ.
11, Hirema Takmadevi,
Here for the respondent number 5.
My objections are not received. You should have it tomorrow.
More.
Finally, my lords. Because they have already completed the next round, despite interim order.
My lord, the petitioner has already reported for the academic course.
Yes.
It's quite another matter. The hearing
Please,
tomorrow-
please, my lord.
The hearing, when it can be done is the.
Please, my lord.
Tomorrow.
Deeply obliged.
orders. Till number 12, Cyril Prasad Payas,
I will comply the office objection, my lord.
Full cost title,
Yes.
legal representative.
the IA may be allowed, 3 of 25.
And counsel for the appellants have been the office objection have been complied.
Full cost
Needful
title
has been done
has to be
at
filled.
Needful has been done. ಎಲ್ಲ ಆಗಿದೆ. All the objections.
I will do it. Today, in the course of the day, I will do that.
ಹೌದು council change ಆಗ್ಬೇಕಲ್ಲ. ಹೌದು.
3 of 25, there appears to be still some of his objection to be.
What about this 3 of 25 bringing a loss? Bringing a loss of the deceased last 7.
Yes, but this is 7th respondent died, my lord.
Huh.
And because they were not aware of the legal proceedings, my lord,
Legal representation
the
I mentioned.
application, he died in 2018. I filed necessary application. What happened is in the application, I have not mentioned the full cost title. Therefore, I have been asked, I will carry out.
1 to 6 ಚಂದ್ರ period ಅಲ್ವಾ? R7 ಗೆ ಹೋಗ್ಬೇಕು. ಅದು ಇನ್ನೂ
Somewhere
ಆಗಿಲ್ಲ.
we need to see there, sir. He's represented. There also that office objection has to be complied to date. He's compliant.
Office objection complied, complied.
During the course of the day.
Counsel for the respondent. The office objections.
During the course of the day, I'll do it.
Yes.
It is there with you.
Undertakes to comply the office objection during the course of the. Yes. Of 25, since the legal representatives of R7, deceased R7 already on record, IA and the learned counsel for the learned counsel Shri K.S. Chandrahasa, Chandrahasa undertakes to file Wakalat, represent them from IA 3 of 25 is allowed. Is allowed. Yes. Next, list for admission. Admit agida.
No, sir, admit agida. Final hearing.
List appeal for hearing.
Final hearing.
Yes, in the usual course. Paper book.
Fine.
Find out.
Yes, below.
Yes. In the usual.
30. So now, Akun.
Appear for appellants, my lord. A week's time may kindly be granted to comply with us.
The request of land council, a week's time granted to comply. Comply the office objection and
Money
file
claim.
paper. Yes, the office notice reveals that the notice served to respond number 5 is returned with the Sharad unclaimed, hence service had sufficient respond number 5. The office directed to print the name of R5 in the cost list.
14.
Please, Lord, appearing for respond number 2. Respond number 3 died. Lord, I may be permitted to file a memo.
Dispensation.
Respond 3 died, and the parties who are already on record are legal representatives.
Appellant is not there.
He died on 22/4/2024.
Where is the appellant? Appellant is not there.
Yes, yes. Adal file madbit. Officer, please file it in the
please.
register.
Because appellant is not here.
Yeah, that's why.
Yes, week's time granted.
Our reporting death of respond
Yes,
number 3. That
the
may be.
counsel for the respondent submits that the
Respond number 3.
respond number 3.
3 died.
Yes, the respond number 3 is
No more.
is no more. As such, is intent to file the report the same.
Please.
Report the same. A week's time grant.
15. P. Mahesha.
For the appellant.
R1.
With respect to R1 Malats, within 2 days, I'll take steps, Malats. With respect to paper book, it is ready, Malats. There are some corrections to it. 2 weeks time, Malats.
From the appellant 2 weeks time granted to furnish 2 weeks time granted, Sankast.
I'm obliged.
Do the needful of that.
Number 16.
16.
Yeah. My lord, in 2 weeks time, I have to file LR application in first matter.
First matter disease respondent.
Taking steps to deceased. File LR application.
LR application.
Yes. The
2 weeks time.
the request of government. 2 weeks time granted to take necessary steps to the deceased respondent.
18/7/24.
16.7 also disease respondent is. 16.7 also you
Yes,
have to take steps.
This is in 16 and 16.7.
16.9.
16.
I appeal for the climate, my lord.
Only here.
Bulb also.
Only
Yes,
here.
R2.
Earlier.
Date may kindly be fixed, my lord.
TF to R2.
16, who has to take that? Adhyar will go.
Cross objector. KB Loknath.
Idara. In 16.1 2 weeks time granted to take necessary steps.
17, Monesh
That-
Kumar
that-
KP.
Well, at 16.11 ಅಲ್ಲಿ. My file memo for reporting death of respondent number 6 million. Therefore, the respondent number, sixth respondent is namely Kannamma, wife of R. Chinnappa, who died none other than the mother-in-law, first respondent and grandmother of second respondent, 2 to 4 died on 30/12/2019.
Take steps.
Yes.
Just 1 minute, 1 minute. R1 to 5 are LRs of deceased, R6?
Yes, ma'am. Well, at the C. Vela Veda,
Correct.
age
the
about 63 years.
R1 to 5 are the LRs. It appears to have been recorded on 8/12/22. But R1 to 5 are the LRs. Then what? R6, no?
R6 is dead, ma'am.
R1 to 5 have been recorded as the LRs of R6. So what is wrong?
Yes, ma'am.
Yes. So nothing further to be done.
And another, my lord, the C. Vela Veda, aged about 63 years, my lord. He is the only legal heirs of respondent number, the estate of left to the deceased person. C. Vela Veda, my lord, the
Number ಹೇಳಿ, respond number ಹೇಳಿ ಯಾರಂತ.
first respondent dead ಆಗಿದ್ದಾರೆ. ಅಲ್ಲ, ಇದು respondent number 6 ಡೆತ್ ಆಗಿದ್ದಾರೆ. ಅವ್ರ ಮಗ ಒಬ್ಬನಿದ್ದಾನೆ ಸ್ವಲ್ಪ ಲೀಗಲ್ ಏರ್ಸ್.
R1 to R5 ಅದು legal heirs.
It's already been recorded.
ಅದರಲ್ಲಿ ಇನ್ನೊಬ್ಬ ಇದ್ದಾನೆ ಸ್ವಲ್ಪ.
ಇನ್ನೊಬ್ಬ ಇದ್ದಾರೆ.
ಹೌದು.
Oh, further.
You file necessary application.
Vela Veda.
Necessary application. Application ಹಾಕಿ.
Application ಮೇಲೆ 28/3/2025 application. ಮೆಮೋ.
ಮೆಮೋ ಹಾಕಿದ್ದೀರಿ?
ಮೆಮೋ ಹಾಕಿದ್ವಿ.
ತಪ್ಪಾಗಿದೆ. Then counsel for the respondent submits that bring the one more legal heir of respondent number 6 has filed a memo dated 28/3/2023.
Because let us see who R1 to 4 are. Nobody is there.
23, 23/2022. So if that be so, the office is directed to put up the memo first. Memo barli matte noda. Memo barli, the order ಮಾಡ್ತೀನಿ.
Let's have a copy.
Yes, survey copy.
Seventeen.
Name of the party.
Lord, in 17.1, my lord, I appear for the appellant. Lord, I am the land loser. I have sought for enhancement of the compensation, my lord. First appeal, my lord, is by the beneficiary. They want reduction of the compensation. My lord, this honorable court, my lord, was pleased to raise objections regarding court fee. On the last date of hearing, my lord, a submission was made that they have paid excess court fee. This honorable court, my lord, directed you convince the office and see it is done. Admit, matter is admitted. Not in view of the urgency, I have also filed paper book. It is because of that clarification, not before this roster, it is posted for the third time.
The corrected matter of appeal for first response. The friend has to serve a copy.
Monesh Kumar illiದ್ದಾರೆ. Where is Monesh Kumar?
Second matter will not pursue the direction of the lordship. My name is show. They have not served the papers to me.
Have you filed wakalat in the in the second matter? Have you wakalat not filed?
Not filed.
You have accepted notice.
Yes. Pursuant to direction of this honorable court, my name is Menche. I request him afraid to furnish a copy so that I can get instruction for file a call.
Acquiring authority, not KIADB.
Let serve copies so that I can know that what is your matter.
Yes.
No. Survey copy and put your copy and put. For the learn counsel, she so and so R1 and R2
R1 only.
R1 undertakes to file wakalat to respond number 1 is re-notify. I ನೋಡೋಣ
ಕೊಡ್ತೀನಿ.
Date could be
1 week.
ಒಂದು ವಾರ.
15/4. 18, Murugesh V. Charity.
Appellant in the second matter, my
The landowners, not these matters.
lords, I humbly pray for 1 week's time, my lords, to
This
file
matter, my
the
lord.
amended cost title.
Just one submission, my lord. One
Why
submission,
1 week's time to amend the cost item?
Lords,
one
any
sub,
day, any date may be given, my lords, I'll comply with the objection.
one
In
submission.
325 or 22 months.
Huh? 434 or 22. I'm for the
Office
complainants
objections
in the
are complied with? First one, first of all.
Non-filing of amended cost title. ಇಲ್ಲಿ ಏನಕ್ಕೆ ಫೈಲ್ ಮಾಡೋದು ಅದನ್ನ ಅಲ್ಲಿ ತಗೊಂಡು ಹೋಗಿ ಆಫೀಸಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
I'm for the complainant, my lord, in the contempt petition.
In which one?
The complaint, which is 18.1, 18.1. And also-
18.1?
I'm the complainant and I'm for the respondents, contesting respondents in both the appeals. The landowners, my lord, have been dispossessed since 81. Not a single shred of evidence has been produced by the authorities to show that they have passed any award or any compensation is paid.
We'll have to hear it on.
That will,
A date may be fixed for hearing, my lord, because this matter has been pending for, they are not prosecuting these appeals and we have been out of possession for nearly 5 decades. We have been prosecuting before different forums, my lord.
the
I request for a short accommodation next
Yes,
week,
yes.
any date may be fixed.
council is permitted to find the amended cost title. The registry,
Munchi
the
matter.
registry.
Next week.
And also to take other, and also to do the needful.
Appellants in
amendment.
325 22.
Yes. CDO, what about the CDO 45 days in filing?
Sorry.
Can be condoned?
Can be condoned, madam.
Delay.
Delay of 45 days.
Please.
I accepting the reason assigned in the affidavit. Accompanied to a 1 of 22. The delay of 45 days in filing this appeal is condoned. According to IA 1 of 22 is allowed. In 434. Next, I tested, yes, we notify this appeal for admission.
Please,
Yes, on date good.
first 1/4,
1/4.
please.
We'll hear of.
Grateful.
19. Saraswati M.
To respondent, please, my lord. Copy also has not been served, my lords.
Compliance of office objections, scrutiny stage, non-filing of acknowledgement. You've been.
No,
copy,
please,
sir.
lord. Copy has not been served on me, please, my lord.
Yes, there is no representation for the appellant. However, finally, a week's time granted.
Please.
To comply the office objection.
Oblige.
20.
But if your lordship could recall, this was where the protectors have turned into predators was our submission. If your lordships could just kindly see the order passed by your lordships on 19/4/2024. 19/4. Because after a lengthy hearing, your lordships had in fact, after the Honorable Division Bench, my lord, passed an order that not to disturb a possession, my lord, they came. Not only disturbed, my lord, what they did was they followed the advocate and the car, stopped at Makery Circle. My lord, they tried to tow the vehicle with the advocate in the car. Then because certain other higher officers had to interfere, and that is the reason why your lordships granted that. Right now, there's, and I must just also bring it to your lordship's notice, the Honorable Supreme Court, my lord, the government filed an appeal against the Honorable Division Bench. Very surprisingly, in the appeal SLP filed by the government, the Honorable Supreme Court again grants us an injunction that our possession should not be disturbed, which is generally unheard of in a SLP filed by the other side and interim orders passed. They were supposed to file their objections in this, my lord. Let them file their reply. It's been quite some time, my lord, they are not filed.
It's 19/4/2024. It says list this matter immediately after summer vacation 2024. This will not preclude the respondents from hearing the.
My lord, those reviews have been withdrawn, all dismissed. Now they have, my lord, if I'll just, your lordship may kindly see this. Court of. Getting dismissed. Court of, you don't. Kindly see, my lord, till the next date of hearing, the possession of the disputed property shall not be disturbed. What your lordship said, my lord, granted in the contempt. The Supreme Court in their appeal, my lord, have said that our possession should not be disturbed. The review petitions have been withdrawn because they filed an appeal. So, my lord, now, in fact, the Honorable Supreme Court, the matter again came up before the Honorable Supreme Court on 9/12. There also, my lord, if your lordship sees,
Your Lordship, kindly pass over this one, learned
no, my lord, let
age.
them file the reply, my lord.
File your,
Learned
replies,
AG
please.
will appear in this matter.
is not the question.
Please, your
Question is this, irrespective of what happens, the contention is that when an interim order was in existence,
Final order,
it- when the order was in existence, it has been
violate.
violated.
clearly violated is the contention. If that be so, you cannot, even in view of the fact that you have filed an appeal, SLP is filed, admitted, all that is besides the point. Please, you must tell us whether there has been a violation, and if so, what is your contention with regard to the violation?
Kindly pass over. Your
That
Lordship.
has
Let
to
them file the reply, my lord.
Pass over.
without filing the reply,
Reply,
how
my
can
lord,
how
there's-
can it be passed over?
So they can take time. He's asking for password. We are agreeing that let them take some time, but let them file a reply.
File is with AG Pradeep.
We are-
My instruction is that, Your Lordship.
Alala, we are saying that for a reply, let them file reply.
So, grant you time ಅಂತ
Please, please, please.
ನಾವು ಹೇಳೋದು ಕೋರ್ಟ್ ನಿಮ್ಗೆ
ಅಲ್ಲ.
ಟೈಮ್ ಕೊಡ್ತಿದ್ದಾರೆ ನೀವು
ಅಲ್ಲ ಅಲ್ಲ ಅವರು ಹೇಳಿದ್ರು as per his instructions I am submitting. Your Lordship.
The learned counsel, the learned AGA appearing for the respondent seeks a short passover. However, in view of the allegations raised in the contempt of court case, we are of the opinion that pleadings are liable to be placed on record. The respondent shall file objections to the contempt of court cases. List after 2 weeks.
Yes,
Please. in-
Lord, on
by-
3rd April.
Steps in respect of R4.
Who's our,
A4 and A6.
who are A4?
My lord, one is, my lord, A1 to 3, my lord, they have been served. Only 4 and 6. In fact, according to us, A4 and 6 are the main who have
Still they are working their own.
they're still working there, but I think the government would represent all of them.
Please, please, Your Lordship.
Pro forma
Director
are
General of
7.
Inspector as well as Commissioner.
A1, who served, A3, X served,
Deputy
A5 served.
Commissioner of Police first. Police.
Are you accepting notice for A4 and A6?
A4 is
Girish, Deputy Commissioner of Police West.
Alok,
Commissioner.
yeah, Director General of Police.
Oh.
SPP office will appear.
Same.
A6
sir,
is
please.
signed,
Inspector.
Police Inspector. Police.
No,
in one case, A6 has signed.
it's,
I think they've signed in the other cases. Deputy Commissioner,
please, Your
Yes.
Lordship.
in the second case, he's A5,
A5,
signed, he served.
A5, Your Lordship.
there is served. Huh? There, I think in the second one, it
Second?
appears that he's been served.
Arun Chakravarti, Managing Director.
Instructing counsel, please find out whether they've been served in the other case. If that is so, nothing further needs to be
There
done.
needs to be, please.
Please, yes. Sure.
Great.
A4 different.
3rd April,
If they've not been served, please see that notice is served as well.
Please.
If the government will accept, then it can be recorded, otherwise they must be served.
but 2nd April. 2nd April,
Third and fourth.
3rd, 2nd,
Second,
Yes.
we've already listed several cases.
None
please, no,
wants to-
3rd let it be done.
Third or any other date?
Yes, then, but
The
10th, my lord.
Yes,
8th, 10th is a holiday.
Oh, 10th,
9.
9th or
15th.
15th.
15.
15, please.
21. K.R. Lingaraju.
Prepare for appellant, my lord.
For
This
the
is in respect
respondent.
of Agachi project, my lord.
It is
Agachi.
Agachi project, Malay. It is Agachi project. My lord, there is 735 days of delay, my lord. My lord, I have already sent the objections to the authority. My lord, a week's time, my lord, I will file the objections and later on.
So for as my lord, this court as well as coordinate bench is concerned, my lord.
I agree, my lord.
Come on, record council, we are aware. Yes.
Date may begin.
Prashant, respond.
Start date.
File objections if any to IA 1 of 24.
Please, ma'am.
Yes.
Date may.
April.
16/4.
Please.
22. Nayakena.
I beg to appear for petition, appellant, my lord. Kindly may I have it, my lord. 1 week later. I will comply the office.
The request of the council for the appellant to 2 weeks time grant.
23 adjourned. Final hearings, number 24, Gurraj Joshi.
Just to have 2 hours is dispensed with. Declaration, injunction, permission to produce.
Please, ma'am.
For a quick perusal, my lordship may please to refer to my additional synopsis
Additional synopsis.
filed on 12/11/2024. That gives some cursory look for this case.
Yes.
I hope my lord has got it. See, it gives a complete picture about the. Here is the case. KSFC is a finance corporation established under the State Finance Corporation Act. In 1980, one Jaswinder Singh has approached the BDA for allotment of a site who has been granted under the lease cum sale agreement. BDA allotted in 1980 and they grant the possession certificate. Based upon that, loan was sanctioned in 87. A letter for loan sanction letter was of 1911 to 87 for running for commencement of the Manmohan roller and floor mill for transfer of loan to Pratap Polypack Private Limited. There is income certificate is there. Then after it has been granted, the additional loan was granted another 18 lakhs. First 12 lakhs, then 18 lakhs, then further agreement, further power of attorney has been executed. Then there is also income certificate is there. Further 12 lakhs 60,000 in 88 was granted. Power of attorney was executed by Jaswinder Singh. Then memorandum of entry was admitted. The procedure and prescribed system under the 58, section 58F, the deposit of title deeds. At that time, what is available is only lease cum sale agreement copy and the possession certificate. In this case, fraudulently what he has done, he has gone back to the BDA without our knowledge. And he said, I lost this portion certificate. You please give me a duplicate portion certificate. Based on duplicate portion certificate, he got said it executed in his favor without the knowledge of the case. Then he has executed based upon that said it. He has executed to X.
Hmm. Hmm.
So because we were under the impression that we are having a agreement and sale agreement and everything, deposit title deeds.
Only one loan was availed by whom? By the company.
By company. He has executed these agreements as a guarantors. Further,
He
in
was a
19
guarantor. He was a guarantor.
Yes.
He also.
he was a partner also, director of the company also. And further loan was granted. Serial number 16, may please be seen. 17,589, third edition sanctioned term loan of 7.4 lakhs in 89. Further loan, additional sanction loan of 91 was granted for 11 lakhs. Further, he has executed the agreement of sale. He has executed agreement. Their special power of attorney was also executed. Then what he has done, there is one mistyping, serial number 24. The serial was executed by respondent number 6 in favor of respondent number 5. By mistake, I apologize for that. Then sale deed was executed by respondent number 6 in favor of plaintiff. There are two portions, first floor and ground floor, which is brother. And brother is executed 1 second sale deed in favor of the plaintiff, serial number 26. Then agreement was there, further agreement was there. In between, when the KSFC has started the recovery actions, they filed a suit. OS 16407 of 1999. They filed a suit.
OS number?
16407. Sir, serial number, my lord, serial number 28. Specifically, that particular suit was dismissed and withdrawn without permission by the court. Without permission by the court, under order 23, 1A, in respect of the provision order 23, without the permission, suit was withdrawn. And he filed subsequently, he filed another suit, OS 1024, against which we are here before my lordship.
Same respondent number 1 himself.
Same.
Same person filed the earlier suit?
Earlier suit, without permission, is withdrawn.
Again filed. Okay.
Now, my submission is on two angles. One is loan angle. Another is once a suit has been filed, which is withdrawn without the permission. So he could not have filed a second suit on the same cause of action against this KSFC.
What was the relief sought in the earlier suit?
Injunction.
Plain injunction suit.
Plain injunction.
That was against whom?
Against KSFC. Appellant. My lord, my further submission is that here, another important point, leaving aside, nowadays, based upon the GPA, the GPA holder comes and enters a witness box, he gives the evidence by sidelining the original parties, for which the Kesari Hanuman case is there of the Apex Court. which clearly says to act in, the word act in the GPA is different than depose on behalf of the principal. He cannot, only after the execution of GPA, he can act subsequently. But he can depose for the acts done before GPA. That is the Apex Court has clarified. And in this way, we are before my lordship.
Yes.
Unfortunately, the learned judge, even though in the WS this contention of the earlier suit was taken, he doesn't act on that particular. My lord, page number 18 of my paper, not on paper book, memo. Page number 18. That is the printed page number 6, pair number 4. Presenting its written statement, my lord has got it.
Yes.
There 6 defendant has resisted the suit as here and here. Once again, there is a mistake by the learned say, whether it is by inadvertently or whatever may be. It is 16407. Instead of that, 14607. Filed by the plaintiff was withdrawn on 14/6/2000. No liberty was reserved for filing the fresh suit. Hence, it operates as res judicata and the suit is liable to be dismissed. Means, my submission is that it has not gone without the knowledge of the learned judge.
Yes.
It has come to the knowledge of the learned judge. Learned judge could have stopped it at this point. He would have asked, have you taken the permission for filing this present suit? If you have not taken the permission, then how can you maintain the present second suit? Specifically, my lordship, in Subha Jain case of the Kerala High Court, rendered by Justice R. Bhaskaran, ಎಷ್ಟಿದೆ ಕಾಪಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀನಿ ಜಸ್ಟ್
ಇನ್ನೊಂದು ಬೇರೆ ಸರ್
ಸಿಂಗಲ್ ಸೈಡ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ ಸರ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ ಒಂದು ಸಿಂಗಲ್ ಸೈಡ್ ಒಂದು ಡಬಲ್ ಸೈಡ್ ಇದೆ ಅಷ್ಟೇ ಒಂದು ಡಬಲ್ ಸೈಡ್ ಇದೆ ಇನ್ನೊಂದು ಸಿಂಗಲ್ ಸೈಡ್ ಇದೆ ಹಾಗಾಗಿ ನಿಮ್ಗೆ ಅದು ಕನ್ಫ್ಯೂಸ್
My lord is
yes.
Back in 2003, this matter was decided by the Honorable High Court of Kerala, Justice R. Bhaskaran, wherein specifically they said when there is a withdrawal of the suit without any permission, which is hit by Order 23 Rule 14 of the CPC. My further submission is earlier, my lordship, the earlier respondent number 1 was represented by one Mr. Chandrasekhar Patil. Unfortunately, 2 months back, his I given him all the copies. No, it's the most of.
Yes.
Fine.
Yes, sir.
You're ready to argue the matter?
Yes, ma'am, please.
But also, they are all my memos were prepared in 2023. Now we are in 25. Please, because of the ill health and Para number 11 to 16 pertaining to this order 23.
Hmm.
In case Bhupati case, my lordship. Sir, no, you know, para number 11 to 16. Ink page, running ink page 13. Running ink page 13. One three.
Yes.
Para 11. my lord. The law as to withdrawal of the suits as enacted in the present rule may be generally stated in two parts. A plaintiff can abandon a suit or abandon a part of his claim as a matter of right without the permission of the court. In that case, he will be precluded from suing again on the same cause of action. Neither the plaintiff can abandon a suit or a part of the suit, reserving to himself a right to bring a fresh suit, nor can the defendant insist that plaintiff must be compelled to proceed with the suit. B, the plaintiff may in the general circumstances mentioned in the sub-rule 3 may be permitted by the court to withdraw from the suit with liberty to sue afresh on the same cause of action. Such liberty granted by the court enables plaintiff to avoid the bar in Rule 2 of 2, Order 2, Rule 2, and Section 11. That is the res judicata, CPC. Further, it is explained the provision of 23, Rule 1, CPC is an exception explained in para number 12 and para number 13, Bhakteshwar Singh. And para number 14, it is a executive officer Anteshwar Temple versus Satyamurthy is explained pertaining to order 23. Question of consideration on the present suit whether the High Court has exercised the discretion vested in it under the order 23 rule 13 CPC on consideration of the matter relevant for the exercise of such power. On perusal of the imposed order, it is clear to us that the learned judge has not considered the matter in its proper perspective while allowing the prayer of the plaintiff for permission to withdraw the suit with the leave to file a fresh suit. Explained further. Look into this, para number 16, last but one para. From the above, it appears that the approach of the High Court was that plaintiff should have prayed for declaration of title which they have omitted to include in the plaint. I am coming to that part. Particularly, my lord, section 34 and 38 of the specific relief act. They have to seek for declaration and they have to seek for injunction. Here only injunction has been sought and the injunction has been granted. Restraining case is a state instrumentality. We are at the hands of my lordship. our hands are tied. It was for the plaintiffs to frame their suit in any firm as advised. If they felt that there was a cause of action for declaration of their title to the suit property, they could have made a prayer in that regard. If they felt that the declaration of their right to exclusive user of the pathway was necessary, they should have framed the suit accordingly. On the other hand, so they continuously explained in last 3 lines, in case such permission is granted at appellate or second appellate stage, the prejudice to defendant is writ large, as he loses the benefit of the decision of his in his favor in the lower court. For the reason discussed for the foregoing paragraphs, we have no hesitation to hold that the imposed order is unsustainable. Accordingly, the appeal is allowed with cost. My lord, the person like Bhupati has to go approach up to Supreme Court, even at the cost of approaching different levels of the jurisprudence. Further, the order of the High Court dated Sunday granting permission to withdraw suit with the permission to file a fresh suit is also set aside. The High Court will now proceed to dispose of the second appeal in accordance with law.
Yes.
My further. So this is as regarding to that we were reading para number 4 of the judgment. Para number 4 of the judgment.
Yes.
But what they have done is we are having a different method and for recovery.
Yes.
Under the SFC Act, we filed a civil miscellaneous under 31(1)AA. There also he tried to implead himself, which came to be dismissed.
Yes.
And he filed a CRP. At the time of this judgment, imposed judgment, that CRP was pending. Subsequently, it came to be dismissed. There is another part, but it is referred here. Miscellaneous 20 of 96 was dismissed and CRP preferred against it is pending. Plaintiff has suppressed those facts. These facts were narrated by KSFC in our written statement. In the matter of prestige lights, madam, my lordship, whenever a party approaches the court without a proper eliciting proper facts, he is not entitled even for a 226 equity or suit for equity or 226. There is a prestige lights case against the SBM. My lordship, the learned judge was of the view, which is the ink page 19. I was referring to Prestige Lights versus State Bank of India in 2007, SCW, page number 5350. Particularly para number 34 and 35. I have not submitted. That judgment I have not submitted. I am permitted to submit. Prestige Lights case, when there is a suppression of the facts by the person who approaches the court. Now coming back to the page number 19. From 7th line, the suit is filed in collusion with the defendant number 2 to 5. that fifth defendant has produced the original possession certificate and a certified copy of the lease cum sale agreement. Certified copy of the lease cum sale agreement. Now we stop here we pause here for a moment. Where is the original lease cum sale agreement? Original lease cum sale agreement is with the KSFC in our records, in our treasury. It is equivalent to title deed. Further, the loan was sanctioned, the first defendant BDA has also given permission to the fifth defendant on the so and so, permitting to mortgage the scheduled property in favor of the sixth defendant as security. The plaintiff, knowing very well, has purchased the suit property in connivance with the other defendants. The sale of the scheduled property is not genuine. This was our contention. My lord, in this case, we look forward for the division bench judgment of this on court, referring to section 3 of the TP Act. Whenever there is a transaction is being taken place, if the transaction, if the originals are not available, original were not produced, which is explained in the section 3. It's called a red herring. My lord, I am reading the explanation to the section 3. A person said to have notice. Section 3. A person said to have notice of fact when he actually knows the fact, or when but for willful abstention from the inquiry or search which he ought to have made, or gross negligence, he would have known it. That means he cannot claim himself as a bona fide purchaser. In one of the cases in Karnataka, what has happened is a person, one Kori Gauramma, has purchased a property which was already mortgaged with a deposit title deed with the Vaishya Bank. Originals were in the Vaishya Bank. Now there is a system getting a certified copy of the sale deeds. They approach the another bank. They approach the Vaishya Bank. They sought for loan. Then the original mortgagee, Vaishya Bank, came to know about it. They actually initiated the actions. She said, I am a poor lady, I have purchased it, and I have a certified copy of the sale deed. I am a bona fide purchaser. This and court, up to the division bench, has held that which, when originals were not handed over to you, you should have the red light, you should have inquired about it, where the original have gone, how they have misplaced. If you are not inquired, you cannot be called as a bona fide purchaser. So, pertaining to this section 3, I will submit that judgment also. In this particular appellation, Kori Gauramma case is there. So, matter went to division bench. mortgage by department of title deeds. Therein, starting from ink page 2, this first appeal by this third defendant is directed against the judgment and decree dated so and so. The ranking of the parties. The suit was filed by the plaintiff Vijaya Bank for recovery. My lord, why is the suit is? Because at that time, there was no Surface Sea Act.
Yes.
KSFC was proceeding under the SFC Act, and other banks were to file the suits. Therein, the suit was filed by the plaintiff Vijaya Bank for recovery of a sum of so and so, which has been decreed by the trial court with interest. The trial court has directed the defendant 1 and 2 to pay so and so amount for a mortgage property. So far as the defendant number 1 and 2 are concerned, they have not filed any appeal. And further, paragraph number 5, it is not in dispute and is supported by evidence brought on record that property in question was mortgaged by defendant number 1 and 2 in favor of the plaintiff bank by way of deposit title deeds, as is evident from exhibit P6, document number so and so, dated so and so, creating mortgage of property in question in favor of the plaintiff bank. It is also not in dispute that the place of is hospit, where a mortgage was created, has been notified town within the meaning of class F of the section 58 of the TP Act. Relevant notification so and so, whereas further, the plea of the appellant, her defendant, is that she is a bona fide purchaser of the property in question for consideration under the registered sale deed, and since the vendor defendant number 1 did not disclose about the mortgage of the property, therefore the property in her possession cannot be sold for realization of the debt owed by the first defendant. Her further plea is that the property in question was not registered under the mortgage deed. Therefore, it was not possible for her to know about the factum of mortgage. I pause here. In India and in Karnataka at that time, the deposit title deeds are not to be registered under section 58F. It is as good as mortgaging a property by a movable item. Further, it bears out from the evidence on record and deposition of the appellant herself that at the time of purchase of the property in question, she has not required her vendor to make available the title deeds of the property in question, and she merely made inquiries in the revenue records as to the whether the property in question was encumbered or not. That means EC entry was not there. Encumbrance certificate entry was not there. Even today, if there is a deposit title deeds, it is not necessary for entry.
Yes.
So far as the registration of mortgage is concerned, 59 of the TP Act specifically provides that a mortgage of deposit title deeds is not required to be registered. Further, it is also well settled that willful abstentions from the making inquiry regarding the actual state of affairs amounts to notice. That's what we have read. I need not reread that section 3. Within the meaning of section 3, in the case of Imperial Bank, it has been held that abstention from the inquiry for the title deeds in a place where one knows that mortgages by deposit title deeds are legal and usual amounts to notice and of the mortgage under section 3 of the TP Act. Similar view has been taken by the Calcutta High Court in so and so case. In the present case, admittedly, the vendor defendant, though obliged to disclose the defects of the property at the time of sale and on demand to produce the documents of title deed, but admittedly he has failed to do so. In that situation, it was incumbent upon the purchaser to insist for the production of title deeds or to inquire regarding the whereabouts thereof. But no evidence has been placed on record to show any such effort was made. In that view of the matter, as held by Privy Council, it has to be held that defendant appellant has willfully abstained from making inquiry. As such, he will be deemed to have a notice of the defect in the title deeds. For the opposite reasons, we do not find any ground to interfere. This is the division bench, matter went up to the division bench, and this was the another judgment on this court. I will take it up subsequently. Compilation. Why not we come to the page number two, in page number 23 of this judgment, input judgment.
Yes,
Printed page number 11, para number 11.
yes.
After 4 lines. Of course, it is brought out from him in the cross-examination. Of course, it is brought out from him that what has happened in this case, the plaintiff is nowhere in India. He has executed GPA in favor of his brother, who is a bank employee, who knows the banking formalities, who was asked to file a suit and get over it. The plaintiff never entered the witness box.
Yes.
Further, of course, it is brought out from him that the lease cum sale agreement was not handed over to the plaintiff, but he has stoutly denied his assertion that plaintiff knew about the mortgage of the scheduled property in favor of the defendant number 6. 6 refunded at the time of purchase. Further, when exhibit P2 and P3 are conspicuously silent about the existence of the mortgage, and the 5th defendant has not come before the court to speak that he has informed the plaintiff of the existence of the mortgage created by him to and in favor of the 6 defendants to secure the loan advanced to the first defendant. It is well nigh impossible for me to believe that the act upon the stand assumed by the 6th defendant by tendering the session. Further, because PW1 has denied it, it cannot constitute any evidence in the eye of law. Even otherwise, no person of ordinary prudence and even an unlettered man would run any amount of risk if he knows about it before doing anything. I skip here. Para number 12. As against what PW1 has deposed, no doubt DW1, there is an officer of KSFC has given evidence, DW1. But there is nothing in it even to indicate or says that plaintiff knew about the mortgage of the scheduled property at the time of P2. On the other hand, when it is an admitted fact that the 5th defendant is one of the directors of the first defendant, the likelihood of he having concealed the existence of mortgage, the scheduled property, then is quite probable. Thus, it has lent some more credence the stand assumed by the plaintiff. Para number 13, my lord, next, page number 13, para number 13, ink page number 25, last 3 lines. Exhibit D12 is the lease cum sale agreement executed in favor of the 5th defendant by the BDA. D13 is a possession certificate issued by the 5th defendant. D14 and 15 are 2 income certificates. D16 is a copy of the legal notice got issued to the 5th defendant by the plaintiff and sent to the 6th defendant. Now, para numbers 15, last 2 lines. Para number 15, page number 15, last 2 lines. Roughly 4 years after the lapse of the term stipulated therein. In the written statement, The sixth defendant has not disclosed or divulged the date of mortgage. However, the date of execution of the agreement and furnishing of memorandum of entry is disclosed, but they are certainly anterior to the date of the P1, making it abundantly clear as on the date of the mortgage, the fifth defendant does not become the absolute owner of the scheduled property. The fact being so, it is not known how did the sixth defendant obtain an equivalent mortgage by depositing title deeds of the scheduled property when the fifth defendant was only a lessee as on that day. My lord, I pause here for a moment. The system in BDA or DDA in Delhi or anywhere in the development authority, they issue a lease cum sale agreements.
Yes.
Thereafter, a particular period, they execute absolute sale deed.
Yes.
In between, this manipulation and malfunctions will take place. But the question remains is that what is the sanctity for the original lease cum sale agreement?
Yes.
The original lease cum sale agreement was the KSFC. If that is having sanctity, then what is the legal sanctity for the duplicate that is the certified copy of the lease cum sale agreement?
Yes.
It becomes a farce and forgery. Para number 18, man. Of course, the sixth defendant has maintained the BDA has given a permission to the fifth defendant on 30th 687, permitting him to mortgage the scheduled property as security in favor of the sixth defendant. But curiously enough, the letter of undertaking is not brought on record, stultifying its defense, besides exposing the falsity in it. In view of this, I am not hesitant, even in the least, to say that there is no merit or substance in the defense. My lord, that is the reason I have filed an IA. My lord, in the cause list may please be seen, I have filed an IA to accept this document under Order 41 Rule 27.
Yes.
As one of the document. Now we are coming to the order. The suit is declared with cost with against the defendants. A mortgage of the mortgage scheduled property created by S1 in favor of the S1 is declared invalid and not binding on plaintiff, and the scheduled property defendant is restrained from means of decree of permanent action from selling the scheduled property under section 31(1)AA of the scheduled property SFC Act. We are sought for IA2, IA1 for permission, attested true copy of the memo of conceding the permission to mortgage issued by the BDA dated 30th 687 is one of the IA, which is pending even today.
Yes.
The reasons has been explained in the affidavit. I state that the appellant has filed the copy of the document sought to be produced at this stage, and the same was not admitted in evidence by the court below, and without considering the said document, the court below has proceeded to pass its judgment in the suit filed by the respondent number 1 herein, and being agreed by the same, the appellant filed this appeal. This is a considerability. Now we are coming to the another question which was not raised at that time. My lord, evidence of PW1 by way of affidavit.
Yes.
Plaintiff is the brother of the PW1 is the brother of plaintiff.
Yes.
My lord, as I submitted earlier, one N.R. Balakrishnan, son of Radhakrishnan, aged about 59 years, so and so, do hereby. I am the registered GPA holder of plaintiff Venkatraman Radhakrishnan. As such, I am fully convinced. I state that plaintiff is a non-resident Indian, now residing in USA, with an intention to settle down in Bangalore after his retirement, and he has purchased the first floor portion of soil. He explains the loans in the first page, pair number 2 itself. He explains the loans. From its previous owner, Sri Jaswinder Singh, who is the defendant number 5 in the suit under registered deed dated document number so and so 94 for a valid consideration of 7.5 lakhs rupees so and so. The ground floor portion of the plaintiff's property has been purchased by the plaintiff's brother Jaykumar Radhakrishnan for a valid consideration, and Jaykumar Radhakrishnan sold the ground floor portion to the plaintiff for a valid consideration of 9 lakhs, exhibit P3, for 9 lakhs. Further explain. Now we come to the pair number 4 of his affidavit. I need not trouble my lordship in all the paragraphs. I'm only taking the cursory look of this evidence. Pair number 4. I further state that originally side bearing so and so, over which the student property has been constructed, was allotted to the fifth defendant Jaswinder Singh by the BDA. He constructed the ground floor and first floor. Lease and sale agreement was executed by the fifth defendant in favor of the BDA, dated so and so. Subsequently, BDA has executed absolute sale deed in 94, which was duly registered in so and so. The original lease cum sale deed and the absolute sale deed are also produced in the Honorable Court with a separate list. But here, originals were not produced. That is the reason I have put the question. Further, he has explained everything. Further, page number 6, starting from page number 5, para number 6. The sixth defendant, that is KSFC, has initiated proceeding under 31(1)(a) of the, that means he has a knowledge, means they are continuously observing the proceedings of the.
Had knowledge in 1999, it says. I further
Yes.
state that on 5/11/99, person claiming to be of.
Yes.
Of the six. That is.
Yes.
Long after the transaction.
Yes.
Hmm.
For the sale of the unleased mortgage property, namely the student property, and the district court Bidar has registered Recovery Proceeding Act, Civil Case 20/96, that is under 31(1)AA. I and the plaintiff were shocked and surprised when the officer of disclosed about the creation of the mortgage in favor of the sixth defendant by the fifth defendant by depositing title deeds, and that there is a threat of sale of the property for recovery of the loan alleged to be due by the first defendant. It is surprising to note that first defendant has not disclosed to us at the time of sale transaction. I pause here for a moment. Means a fraud was played, initially fraud was played by the first defendant against the fifth defendant and plaintiff, which cannot be attributed to the case. Further, therefore, immediately I and plaintiff approached the district court with an application under Order 1, Rule 10 of CPC to implement the plaintiff as a party to the said proceeding, the London District Court by an order dated so and so dismiss the application filed with the plaintiff under Order 1, Rule 10 CPC, holding that the proceeding pending before the district court initiated by the sixth defendant is not a suit. Therefore, Order 1, Rule 10 CPC is not attracted as such, it cannot be invoked. Then that means they are aware about our proceedings. It is further submitted. Now, para number 8, starting from 6th line. Thus, the fifth defendant has suppressed the important. That means the relief for the plaintiff is with the fifth defendant, who was the loanee, who was the guarantor to the KSFC. So he is the person who has suppressed. That in that view of the matter, my lord, the court could not have restrained the sixth defendant KSFC from executing our actions. Further, thus the fifth defendant has suppressed the important and material facts and sold the swing property to the plaintiff. Thereby, he has defrauded the plaintiff. He admits in his evidence. It is pertinent to note that the mortgage of the by depositing title deeds alleged to have been created by the fifth defendant is illegal and invalid. Even otherwise, as stated in some, fifth defendant is none other than the brother of the second defendant who has suppressed the factum of the lease mortgage before the sale of the property. Plaintiff, thus he has intentionally committed fraud upon the plaintiff as stated above. The plaintiff has made all the reasonable inquiry about the transactionable, transferable interest of the fifth defendant in the sale property before entering the sale transaction. Here there is a short of, my lordship, section 3. Section 3 explanation. Lease cum sale agreement executed by the fifth defendant in favor of the BDA specifically prohibits him from creating a charge on the property by a mortgage or otherwise. The fifth defendant has in unequivocal terms undertaking not to mortgage the property to anybody except to the government or banking, housing boards, life insurance corporation or housing cooperative society, and that too for the purpose of obtaining loan for the construction of house. On the date of execution of the lease cum sale agreement, the BDA has not executed any absolute sale deed in his favor. Thus, there was no title deed in favor of the defendant in respect of the suit property. On the date of the alleged mortgage is created in favor of the sixth defendant. Therefore, unless they try to harp upon the case, that means without sale deed, how could you grant the loan?
Yes.
So last 4 lines of that particular page, fifth defendant was only a lease lessee and intending purchaser of the property. My cross-examination is there. Now we come to the cross-examination. In the cross-examination,
Yes.
after about 7 lines.
Hmm.
D5 has handed over the duplicate position certificate. Initially, he said original position certificate. Now he admits in the cross-examination that position certificate is with KCFC. Cross-examination. Duplicate position certificate. I do not know whether defendant D1 has handed over position certificate letter issued by the BDA permitting D5 to mortgage the assumed property to D6 while creating a mortgage. The plaintiff has admitted in CRP that the scheduled property cannot be mortgaged to anybody except financial institutions. KSFC is one of the financial institutions. If it is suggested that because the plaintiff knew about it, purposefully he has not produced the lease sale agreement, I do not know about its execution itself. I have seen exhibit P3. If it is suggested that even though the plaintiff knows about the lease sale agreement, it is not produced, I do not know about it. Pair number 2 of the cross-examination. After the 4th line, if it is suggested that with a view to defraud D6, D5, and myself created D6, that is case of C, defined myself as created P3 in collusion, I was not knowing the mortgage liability. It is false that even though the plaintiff knows about the mortgage completely, he has given me the GPA to depose on his behalf, carrying on an impression that he comes to the court. If he comes to the court, the truth will come out. It is false that even though I do know about the mortgage, I have deposed falsely to cause the loss to this. Last 2 lines. I do not know whether D5 has executed all the necessary documents while taking this. Thereupon DW1 is our officer. Yes. Now we come to the settled position of law.
Yes.
Settled position of law. My lord, exit P15. Exit P15 is a GPA executed by the plaintiff in favor of the PW1. Sorry, it is not there in the paper book.
It's all right.
But there is one more submission with due respect. In the High Court rules, there is a procedure for filing the cost for preparing the paper book by the court itself. Unfortunately, it is not being implemented. With due respect.
Yes.
Loss of manpower or whatever it may be. In the entire GPA,
Yes.
in entire GPA, Manoj got it?
Yes.
GPA. Is it P615? Pair number 2 to apply for the BDA, Bangalore City Corporation, there is a BBMP for getting all the permissions. To apply for the BESCOM, there is a Karnataka Electricity Board. And pair number 4 to apply for the BDA, City Corporation or any other to and represent me in judicial.
And quasi-judicial authorities, tribunals and other authorities.
Yes.
All or any of the matters connected with the scheduled property.
Scheduled property.
Hmm.
To to appoint professionals to grant them necessary authority to represent us before the BDA, to pay development charges, to deal with the para number 7, to deal with assessment department of this concerned corporation of city of Bangalore, and para number 8. Now we come to the last para, last two paras. To apply and to secure change of land use, that is under section 14 of the Town and Country Planning Act, if there is any change from converting from residential to commercial, commercial to, for making such application. And generally to do all other acts, deeds, matters and things in connection with the securing approval of the plans without any restrictions and reservations or conditions in the same manner, and to do the to the like extent as I could not do as the absolute owner of this one. All acts and deeds done, things lawfully done by my attorney shall be binding upon me. This is the end of it. Now we come to the, based on this, unfortunately, general notion is that if there is a GPA, he can do anything, even for sale or execution of the documents or to give evidence. In the Apex Court in the 2020. But it was 2013 itself. But a compilation of my
Yes.
But what is 96? But what is today I have submitted a compilation along with Korigaurama case. In that second judgment is of Apex Court, reported in 2013, 12th volume SEC 64, and along with all the other journals. Yes, Kesari Hanuman Gowda. I not trouble my lordship in all the, this one, particularly para number 23.
Kesari Hanuman.
Kesari Hanuman. Kesari Hanuman Gowda versus Anjum Jahan. The matter went up from Andhra Pradesh. Para number 23. Ballot has got it.
Yes, yes.
It is settled in legal position that the power of attorney holder cannot depose in place of the principal. The provisions of Order 3, Rule 1 and 2 of CPC empower the holder of the power of attorney to act on behalf of the principal. The word act employed therein is confined only to acts done by the power of attorney holder in excess of the power granted to him by virtue of the instrument. The term acts would not include deposing in place. The acts will not include the deposing in place. and instead of the principal, the acts would not include depositing in place and instead of principal. In other words, if the power of attorney holder has preferred any acts in pursuance of the power of attorney, he may depose for the principal in respect of such acts, but he cannot depose for the principal for the acts done by the principal and not by him. Similarly, because my lordship, exhibit piece 15 is of 96. Prior to that, whatever has happened between the plaintiff and the defendant number 5, whatever the execution has taken place, whatever he has done, they are all acts. There is no authority to give a deposition.
Yes.
Similarly, he cannot depose for the principal in respect of a matter as regard to which only the principal can have the personal knowledge and respect of which the principal is entitled to be cross-examined. Here, once again, para number 16 of the Vidyadhar versus Manikra case is the apex court. Even today, it is being referred to in the whenever a party to the suit is not entered into the witness box, read with 114 of the Evidence Act.
Yes.
So far as the notice of agreement, the other conditions are there. Means here, the person who has executed,
Yes.
the plaintiff has not entered into witness box. The person who is holder of the GPA has entered into witness box and he was not available. The plaintiff was not available for a cross-examination. The presumption, legal presumption, can be taken against him. Why what prevented him? He would have taken time from the lower court.
Yes.
So in that view of the matter went up the para number 26 of this one, Kesari Amanagoda. In view of the above, the appeals are allowed, the judgment and decree passed by the High Court is set aside. And the same was passed by the trial court is restored. As a consequence, the appellant is entitled to get the stated executed. So and so means it goes to show that unless we go approach the apex court, we will not, a person will not get justice. If he stops at the level of High Court, there is a possibility that he may not get.
ಇವತ್ತು ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದು ಒಂದ್ ಕೊಡ್ಲಿ ಅಂತ ನೀ ಕೇಳಕ್ಕೆ ಒಂದು ಸಿಗುತ್ತೆ ಅಂತ.
My lord,
Yes.
as regard to the additional document has submitted, an IA, which is also pending, for which I have submitted my
Yes.
synopsis along with the citations of 2022 of the apex court, where the 4127 is applicable, is the RFA is permissible.
Yes.
Where number 3 to 6. I will not trouble my lordship in that move. Some more judgments are there. Sir. Court officer. Told. Yes. Some more judgments are there which is supporting my submission. Regarding a GPA in a Janaki West, there's a 2005, and just now I have submitted there's a Vidyadhar versus Manik Rao and Ram Prasad, Rajasthan High Court. When I was explaining to my juniors, I say all these judgments or citations are like index fingers. They explain, they guide us which direction we have to look into. Unless my index finger is molded back.
Yes.
So appeal deserves to be allowed. Therein also same judgments with the other internal page number just now has what I submitted. Ink page number 8, pair number 15 may please be seen. Ink page number 8, pair number 15 of the Janki Vasudev Bhojwani versus the IndusInd Bank. Apart from what has been stated, this court in the case of Vidyadhar so and so, where a party to suit does not appear in the witness box and states his own case on oath and does not offer himself for the cross-examination. Means here what the apex court was of the view that
Yes.
it is not like the order 3 rule 1, 2 cannot be used as a shadow boxing.
Yes.
You have to enter. If you are a party, if you are a plaintiff, you want the justice, the court of justice will grant whichever what is feasible as on that day. A presumption would arise that the case set up by him is not correct. Specifically, the apex court says, which has been 99 judgment has been recollected in 2004. Further, the civil dispute, in civil dispute, the conduct of the party is immaterial. But not here, a person, Venkat Radhakrishnan, he sits in America.
Yes.
I agree, I don't dispute. He might be NRI. He has purchased the property. But when he wants to produce his case, he has to appear. He has to depose. He is subject for the acid test. The appellants have not opposed the court with clean hands. So here the unclean hands is there. From the conduct of the parties, it is apparent that it was applied to salvage the property from the sale of in the execution of decree. Further, pair number 18, the aforesaid judgment was quoted in by the approval in the Ram Prasad versus Harinarayan. Further, Rajasthan, it was held that the word acts used in the order 2 of the rule 2 of the order 3 CPC does not include the act of power of attorney holder to appear as a witness on behalf of the party. Power of attorney holder of a party can appear only as a witness in his personal capacity, and whatever the knowledge he has about the case, he can state on oath, but he cannot appear as a witness on behalf of the party in the capacity of that party.
Yes.
In the plaintiff, further, pair number 20.
Yes.
Bombay High Court has been referred.
Yes.
With the other Manik Rao case, also I have pair number 16 of that particular judgment. With the Manik Rao case, there is a pair number 16, where a party, ink page 19, where a party to the suit does not appear in the witness box. Party to the suit, not as GP order, madam. I am speaking once again. Submitting party to the suit and states his own case on oath, does not offer himself to be cross-examined by the other side, a presumption would arise that the case set up by him is not correct, as he has been held, as has been held in a series of decisions passed by the various high courts and the Privy Council. This was followed by so and so, so and so, so and so. I skip all this. Further, held that if a party abstains from this entering the witness box, it would give rise to the inference of adverse position adverse against him. Similarly, a division bench of the Punjab and Haryana High Court after 1974, presumption under 114. In this case, defendant number 1 himself was not a party to the transaction at sale between the. And as far as Ram Prasad case of Rajasthan also, I have appended here. Page number 29 and 30, 31. In this way of the matter, I pray before this report that it's a fit case for allowing my appeal by considering the IA number 2 filed for the R41 Rule 27. Considering the permission granted by the BDA. At the end of the day, my lord, it's a public money, it's not somebody's private, it's not somebody's private money which we are referring. For last 15 years, we are working and we are approaching before this court for a public money.
Yes.
Hence, appeal may please be allowed with suitable costs.
Please, bro. May I make?
Yes.
Appearing for respondent number 1 in this matter, my lord. Plaintiff before the trial court. The first ground, my lord, urged by the other side. That is, my lord, the OS number 16407 of 1999 was, my lord, filed by the plaintiff.
Yes.
That is the respondent herein. And, my lord, by suppressing the material facts, my lord, I approach this court. That is, my lord, the first ground.
Yes.
I would like to, my lord, draw the attention of your lordship to the said suit, my lord, filed by the very plaintiff for the relief of, my lord, bare injunction. My lord, I request, my lord, to see the paper book, page number 7 of the prayer for a moment. In the present suit in hand, my lord, the relief sought for is, my lord, declaring that the mortgage created by the 5th defendant in favor of 6th defendant is invalid and not binding upon the plaintiff and the suit property. And, my lord, there is no res judicata and there is no suppression of fact, my lord. It is not necessary, my lord. And your lordship may kindly see the earlier suit, my lord, filed only against KSFC.
Yes.
In the very same suit, my lord, the appellant herein entered appearance and filed its written statement, my lord, contending that the suit suffers from non-making of necessary party. That is their contention. And at the same time, they have also brought to the notice of the court that, my lord, a petition was pending before the district court at Bidar, wherein the miscellaneous petition was filed by the appellant for recovery of money against the, my lord, the borrowers. In that event, the circumstances constrained me to withdraw the suit. As the same was, my lord, suffers from making a necessary parties, as well as to, my lord, I have, my lord, filed a memo requesting the court, my lord, permit me to withdraw the suit. The memo reads as follows. The plaintiff above named does not propose to pursue this suit any further, and as such prays that he may be permitted to withdraw the same with liberty to pursue the other remedies that are legally available to him against the defendants before the appropriate forum. My lord, in that event, my lord, whatever the, my lord, contentions raised by the other side with respect to the maintainability of the very suit, my lord, cannot be accepted, my lord.
What was the order of the court on that?
Court, my lord, accepted memo, my lord, and permitted me to withdraw the.
It is accepting the memo that.
Please, my lord. Get it, copy. The last page may kindly be seen, my lord. It was written in handwritten, my lord. Last page, memo was accepted. On the bottom, my lord. On the bottom, last page, my lord. Right side and my lord, on the bottom. It was stated that, my lord, a memo was came to be filed by the plaintiff and requested the court to withdraw the suit. Accordingly, my lord, the suit was withdrawn.
The plaintiff files memo stating that plaintiff be permitted to withdraw suit. In view of the filed memo, court of plaintiff is dismissed as now.
Please, my lord. Accordingly, my lord, in the memo, my lord, I very clearly have stated before the trial court that, my lord, to work out my remedy, my lord, I have filed that memo. And insofar as prayer is concerned, my lord, whatever the prayer urged before the earlier suit is entirely different from the present suit, my lord. In that view of the matter, my lord, that contention, my lord, cannot be acceptable. And your lordship may kindly see the next, my lord, ground. Insofar as the present plaintiff is concerned, my lord, he is not aware of the what are all the, my lord, facts, my lord, much prior to happen between the parties. I request my lord to see exhibit piece D18 for a moment. Para number 5 of the agreement. This is the, my lord, the very important document based on the.
Yes.
Based on the, my lord, entire suit is, my lord, defending. The lessee or purchaser shall not alienate the site or the building that may be constructed thereon during the period of the tenancy. The lessor vendor may, however, permit the mortgage of the right, title, interest of the lessee purchaser in favor of the government of Karnataka, the central government, or bodies corporate like the Karnataka Housing Board or the Life Insurance Corporation of India, housing cooperative societies or banks to secure monies advanced by such governments or bodies for the construction of the building. Like, it is very important to note here. A loan can be availed by mortgaging the property. By mortgaging the property, that is the, my lord, scheduled site at that point of time, only to construct the building. Apart from that, my lord, it is not permitted the person who obtained the lease cum sale deed to mortgage the property as a collateral security. This is the very important, my lord, document. But here it is a case where the contention of the other side is that, my lord, the present property was given, my lord, as a collateral security to obtain a loan. That is not permissible. When the law, my lord, is not permits, when the very document produced by them, he states that, my lord, the loan can be availed only for the purpose of construction of the property in the very same site, my lord, the question of granting loan does not arise. Subsequently, my lord, based on the, my lord, the lease cum sale deed, a registered sale deed is, my lord, came to be executed in favor of the, my lord, defendant number 5. In turn, my lord, he sold the same in favor of the, my lord, plaintiff herein. My lord, there is no occasion for me to see the document, my lord, with respect to the execution of the mortgage is concerned. Neither it is not reflected, nor it is not disclosed by the other parties. I am a bona fide purchaser, my lord, invested the, my lord, hard earning money, and my lord, have secured the, my lord, the property by executing the sale deeds. The clause 5, my lord, very clearly goes to show that, my lord, this property cannot be offered at all.
Yes.
When such being the case, my lord, how, my lord, the mortgage deed can be executed in favor of the, my lord, the bank? Under such circumstances, my lord, they are not entitled for any relief at all. And my third ground, your lordship may kindly see, in the year of 99 itself, admittedly there was a miscellaneous petition was pending before the Bidar court that is instituted by the other side for the recovery of money. What is the fate of the miscellaneous petition? It was dismissed. And subsequently, a miscellaneous petition was, another petition was filed to recall the dismissal order. That is also came to be dismissed. Even till today, since from 1999, they have not taken any steps to recover the money. Like the borrower is one side, the collateral security offered by the other side person, that is the defendant number 5, is on another side. They colluded to each other. I don't know whether with the KSFC or not. I don't know. I don't have any knowledge because I can't make that allegation. I am a bona fide purchaser, having, my lord, without there being any disclosure of the material on record. How, my lord, I am expected to be, my lord, to know all these documents, my lord? Even till today, my lord, they have not, my lord, initiated not even a single proceedings against the, my lord, the original borrower. Whatever the proceedings executed, initiated by them are all, my lord, went in vain. Under such circumstances, my lord, it cannot be held at, my lord, against me. And my fourth ground may kindly be seen, my lord. Lord, insofar as, my lord, res judicata is concerned, the principles of res judicata cannot be made applicable to this case. Because of the reason that, my lord, the parties are in both the suits are entirely different, and the prayer made in both the suits are entirely different. And, my lord, the first suit is not attained finality. Lordship may kindly see, they have relied upon on the judgment, wherein, my lord, that is 2001 2 KR LJ 524, that is, my lord, memo of citation was given by the other side. The Vaisya Bank Limited, that is Kori Gauramma case, my lord.
Yes.
My lord, in this case, the principles of this case, my lord, cannot be made applicable for the simple reason recovery proceedings was initiated by the bank. That is the reason where the defendant cannot raise a question or voice saying that, my lord, I don't have any knowledge like that, my lord, she can't put forth that argument. But here it is a case where the suit is filed by me. The corporation kept quiet for a long time. According to them, my lord, they have given the money to the one borrower. The defendant 5, my lord, he is a collateral security, he was given the property. Almost, my lord, 25 years, my lord, elapsed after 1999. The Kori Gauramma case, my lord, it is entirely different, my lord. The suit was instituted by the bank.
What do you say about the contention that the general power of attorney holder cannot
My lord,
impose?
But insofar as power of attorney holder is concerned, I request my lord to see at the deposition of DW1 for a moment. That is in page number 25, paper book running page 25, my lord. Cross-examination part, my lord, in the middle. I am working as deputy manager since 7 years. P.R. Srinath is still in service of D6. D6 has not given me written authorization to give evidence on its behalf. My lord, they themselves cannot enter witness box and they cannot depose evidence at all. He categorically admits before the court that my lord, he had not any authorization. How, my lord, his evidence can be treated as evidence? And insofar as, my lord, GPA is concerned, my lord, the person who purchased the property is sitting in USA as admitted by both the parties. My lord, the judgments quoted by the other side categorically states that, my lord, a person cannot depose merely because he is a GPA holder. He must act purportedly some of the acts to be done. My lord, my lord, got the GPA way back in the year, my lord, 19. exhibit P15, 1996 itself. Since then, my lord, I am looking after the property. I am taking care of the property. The suit is came to be filed subsequently. It is not the case that, my lord, suit is filed and I am intervened as a GPA holder. The suit itself is filed by me as a GPA holder. GPA is 3 years old at the time of filing the suit. And there is no bar as such to, my lord, a GPA holder can enter a witness box. I agree, my lord. I agree with your lordship and the citation, whatever cited, wherein a GPA holder has not acted at all. In the present case in hand, I am standing in a different foot, my lord. I had acted upon. That is the reason in the GPA, it is categorically explained the entire thing and entire acts. What all the acts to be done? I am authorized to do everything with respect to the property. I am taking care of the property. Then, my lord, those, my lord, citations cannot be made applicable to the present case in hand. May I read few findings of the judgment, my lord, under challenge? I request my lords to see page number 30 in the paper book, pair number 12.
Yes.
As against what PW1 has deposed, no doubt, DW1 has given evidence, but there is nothing in it even to indicate or suggest that the plaintiff knew about the mortgage of the scheduled property at the time of exhibit P2. On the other hand, when it is an admitted fact that fifth defendant is one of the directors excuse me, of the first defendant, the likelihood of he having concealed the existence of mortgage of scheduled property then is quite possible. Thus, it too has lent some more credence to the said stand assumed by the plaintiff. In view of this, I have to believe his claim that he was a bona fide purchaser of the scheduled property for valuable consideration and act upon it. My lord, next page, my lord. Page, para number 15. Para number 15, my lord, next page, 31. As could be seen from exhibit D12, it had been executed on 8/5/1980 and the period stipulated was 10 years. To be specific, as per clause 1 of it, the fifth defendant was put in possession of site I has in his capacity as tenant to enjoy it for a period of 10 years. As per clause 12 of it, at the end of 10 years, the lessor had an obligation to sell the same to the fifth defendant. The period of 10 years had come to an end on 7/5/1990, but as could be seen from exhibit P1, it had been executed in favor of the fifth defendant on 10/1/1994, roughly 4 years after the expiry of the stipulated period. But that means to say, my lord, the entire process, whatever my lord BD has to be done, it is my lord, in accordance with law, it has been executed. And after 4 years, my lord, it was, my lord, executed in favor of me. If the correct sense of law, by following procedure, if the loan was granted, my lord, that property, whatever given as a collateral security, my lord, cannot be taken at all. Because of the reason that, my lord, as already I pointed out, my lord, the clause is very clear in the lease cum sale agreement itself that, my lord, that cannot be offered to any institution to obtain money or borrow money. And, my lord, DW1 entered the witness box without authorization. My lord, when he himself, my lord, sitting in the glass house, and, my lord, now he is throwing the stone on the plaintiff. And even till today, my lord, one more submission I would like to make. even assuming for a moment, my lord, whatever the petition he has filed is dismissed. Even that I have executed my principal has executed GP in my favor. My lord, what steps they have taken, my lord, to take the property at least to recover the money, my lord?
Where is the finding with regard to that dismissal?
Dismissal of my lord. My lord, we don't have any copy, my lord, but we have knowledge that, my lord, it was dismissed. My lord, it was dismissed for non-prosecution. I'm sorry. It was dismissed for non-prosecution. The petition filed by them was dismissed for non-prosecution. Subsequently, an application was filed. That is also dismissed. That we have produced, my lord, along with my lord.
They've already, this is part
Yes,
of
my lord.
record.
We have produced along with a memo. I will point out, my lord.
So there does not appear to be any such finding in the judgment.
No, my lord. No, my lord.
Not referred
No,
to.
my lord. My lord, no steps have been taken so far. I'm a bona fide purchaser. Even, my lord, even the other side has also make a mention saying at that point of time, there was no practice in entering in the increment certificate with respect to the existence of mortgage. My lord, how can he expect me to know the mortgage then? Who else tells me 1990 was the sale deed executed by the BDA, 94 is the sale deed executed by them to my vendor. I was in possession of the property since from 1996. Lord, it is available with the court. Exactly, my lord. I don't know the date, my lord, but it is available with the court. I have produced it, my lord. A copy of the, my lord, memo. May I pass on, my lord? I have only one copy. Memo. Along with memo, madam. Other. It is available. And my lord, one more submission, my lord, I added to it. I would like to make, my lord. Till today, my lord, they have not taken any steps against the original borrower. In fact, my lord, the primary liability may be, my lord, true. As a collateral security, my lord, the present property was given. But at the end of the day, my lord, there is a primary liability on the borrower. They never, my lord, made any attempt to secure him or to, my lord, recover the money.
Yes.
For this reason, my lord, they don't, my lord, any, my lord, voice to say that, my lord, the decree under challenge, my lord, is unsustainable.
Just
Yes.
one. You may read the memo filed by them.
Yes.
The law. Madam, I will not repeat. I just making some corrections.
Yes.
Order 23 Rule 3 B of CPC. It may on such terms as it thinks fit grant plaintiff permission to withdraw from such suits or such part of the claim with liberty to institute a fresh suit in respect of the subject matter of suit. Specifically, suit has been mentioned.
Yes.
Suit cannot be equated with other remedies.
Yes.
But whereas the memo blindly has filed other remedies, not for filing suit.
Yes, only other remedies. Yes,
Memo.
yes.
Memo doesn't speak regarding other. If filing a second suit or fresh suit, if it is sought and if it is granted, then they would have 1204, 1024 is legally permission. If in the absence of it,
Yes,
there are different judgments of this our honorable court that if the permission doesn't specify, the plaintiff files memo stating that the plaintiff be permitted to withdraw the suit in view of the filed memo, the suit of the plaintiff is dismissed as not pressed without any permission to grant.
yes.
If no permission is granted, it cannot be presumed that permission was granted.
Yes,
So permission to file a first suit was not sought. Further, my lord, coming back to section 3, abstention from making inquiries amounts to notice.
yes,
If I don't make any inquiries, it amounts to notice. There is a law. When a duplicate possession certificate, duplicate lease cum sale certificate, originals are with the KSFC, they would ask one question: where is the original? They would not have.
where does the sale deed refer to a earlier lease cum sale agreement?
That is with the KSFC.
Sale deed,
Huh.
1990, does not refer to an earlier lease cum sale agreement.
Subsequent to the sale deed on lease cum sale agreement only, sale deed is executed.
Correct. But the 1990 sale deed is a sale deed full and proper. It
Yes.
does not talk about any earlier document
Yes.
or anything. And the lease cum sale agreement was
Yes.
for a period of 10 years from 1980.
There's a mother.
It is for a period of 10 years from 1980.
Yes.
The period of the lease cum sale agreement expires in 1980.
Yes.
Therefore, you would have been aware. This theory of due diligence is applicable to everybody.
Yes.
You would have been aware that after 10 years from 1980, if nothing else, nothing untoward happens, he would have been issued with, he would have been, there would have been,
Fresh lease comes
there would have been either a sale deed
or
whatever. Therefore,
extension of the lease cum sale.
therefore, was it not for you to have, you are the mortgager?
Yes.
I mean,
Mortgage.
yes, the mortgager. Therefore, is it not for you? to
Mortgagee.
have- Mortgagee, yes, correct, sorry. So is it not for you to have sought for the sale deed, the production of the sale deed? Because otherwise, till then, he is only a lessee in the property.
Yes.
He is a lessee and an agreement holder. The lease is specifically for 10 years.
Yes.
1990, according to you, when the loan is still in operation, they are in default. You do not even require him to produce a sale deed before you. You do not require him. He is very much in your hands at that moment.
It was
Do
required.
nothing.
It was required. It was
Do
required.
nothing. Therefore, the due diligence part of it, according to us, is applicable as much to the KSFC, who is dealing with public money to a much higher degree than a private person who purchases the property. It is not your money that you're dealing with. He has taken a risk with his own money. You are dealing with the public money. You should have asked him to produce the sale deed before you in 1990.
Yes.
And if he does not, you should have sought for other security.
Yes.
Is that not so?
Yes.
Hmm. Yes.
But the depose and acts, apex court has settled. Even today, I assessed yesterday.
Hmm.
Is there any change of the opinions of the apex court?
Hmm.
One last submission, may I make one last submission?
Yes.
Even the application for additional document cannot be acceptable. Why? Because according to them, it was available long back. But what prevented them to produce before the trial court? That is the only submission.
No, I submitted in the affidavit.
Tilkens.
It was.
Twenty-five, L.R. Naik. Till number 25.
Content of this meeting is being sent to a third party. Do hope the third party is a registry of this court. Content of this meeting is being sent to a third party. There is a message, the content of this meeting is being sent to a third party. Please ask the registry whether it is being sent to the cloud by the registry. If not, what is this? Twenty-five partition suit.
25.
I'm waiting for the respondent.
We won't start. Because we have quite a few of the reserve judgments. We won't start a partition suit today.
Pardon, ma'am?
Next date.
We'll
Adjourn.
have this
Because it
some
is-
other day. We can't start a partition suit today because we have some pending judgments.
My lord, it's a simple matter, my lord. The respondent, the parties are sisters.
Ah.
And they inherit the property through her mother, their mother. So the mother has got the share.
Hmm.
She died intestate.
Hmm.
So naturally, they get equal right over the property.
Hmm.
Accordingly, the trial court has granted the partition, giving off share to the respondent, my lord.
Oh.
In view of the stay order, my lord, the FDP proceedings have been starred.
Then it has to come.
Appellant.
It has to come.
He has
It will
taken,
be very simple for you. It may not be quite so simple for the appellant.
but he
because
has taken
we
much time.
simply lost before the trial court.
The FDP proceedings was already completed, my lord. By virtue of the stay order granted by the Honorable Court, my lord, they are not in a position to come and conclude the FDP.
My humble request, my lord,
Yes.
I am going to file synopsis, my lord, today. I'll serve the copy to my learner friend. Kindly may I have it on Wednesday, my lord?
Next week.
Yes, short date may kindly be given.
Yes.
A
Short
date
date
may
may.
kindly be fixed, my lord.
9-4.
Much obliged.
26 urgent, 27 Chandrasekhar R.P. Party.
Land acquisition. On some roads. Land acquisition. 728.
29, 30.
728 is land acquisition.
Maybe next week.
Yes.
8-4. 28 Narsimurthy GV.
We thought if somebody is ready in land acquisition, we could take it up. The other matters may take time.
28 Narsimurthy.
Morning, they sought time. Can be on some other day, please. List it on some other day.
9-4. 29 Krishnamurthy MR.
ಹಾ. 28 ಅಲ್ಲ? 29. ನಮ್ಗಿದು 28 or 29. Something being authorizedly done by the registry? No. Let's ask the registrar whether it is being sent to maybe cloud or something like that. Please. It is the one. 87 is the same. What do you say? 52 grant. 79, the act comes into force. 87 is the same. Only 8 years delay. Within 8 years, the same. When do they come before the commissioner after 87? Initial application is made when?
Hmm?
1905-2000. 13 years. 13 years delay. 13 years, is it possible? Which is the judgment?
Like Neckanti judgment.
Neckanti.
Neckanti.
Yes. 13 years is covered? It's too long.
No, your.
Can be.
Yeah.
Within what time? 12
There
years?
is no limitation is fixed in
No
that.
limitation is fixed, but the court said if it is beyond the time for claiming adverse possession, 12 years, after 12 years, it can't be filed.
That is a adverse possession, your lordship. It's under KPTC.
That was a principle. After 2 years, I mean, after 12
After
years.
years.
After 12 years, there cannot be an application for restoration.
Yeah, that is their case for
This is
restoration.
in your favor. You are for the?
No,
appellant
they
is-
are for purchaser, not for.
Correct. If they are for the purchaser, they're saved. Because after 12 years, the application for restoration is time barred.
And present coordinate bench has, because that act has been challenged, that is pending before this.
This is quite another matter. Act challenge the very same thing. In pari materia acts all over the country have been upheld. It's not the act challenge may not be a ground. 87 is the same. When is the application before the commissioner? If it is in 2000, it is beyond 12 years. If it is beyond 12 years,
Sale is
Difficult.
87, your lordship. Application 1999, your lordship. 27/8/1999.
27/8.
Please, sir.
Sale is 16/10/87.
16/10/87.
No problem.
Yeah. 99. 12 years. 12.
Appellant, please look this up. Please look this up. Please.
12 years.
12 years, 13 years business, will it make a difference? Please tell us. Okay? Yes, when counsel for the appellant seeks a short accommodation list after 2 weeks, interim order shall remain in force till the next date of hearing. Yes. Number 30. PC Raju.
See, number 30 minutes, the respondent number 1, DRT, has been arrayed as party and notice has been dispensed with. In fact, DRT cannot be arrayed as a party in any of the proceedings since the judicial proceedings are initiated. 30.
Lord, I appear for the appellant
Yes.
in this matter. This is a very short matter, my lord. What has happened is, in 1993, bank files a recovery suit,
Hmm.
because this is before the RDDB Act was there. In 1993, a suit for recovery of money is filed by the bank against the principal debtors and the so-called guarantor. I am supposed to be the guarantor.
Hmm.
Lord, after I am not served the notice,
Hmm.
the principal debtors appear before court and file a memo consenting to a decree. The office, while drawing up the decree, I am D4. It's only R1 to R3 consent to the decree.
Hmm.
But office, while drawing up the decree, which is a ministerial act, saying jointly, all defendants jointly and severally liable is what is stated.
Hmm.
From 1994, for the last 30 years, I have been fighting to say that please proceed against the persons who consented to the decree, not against me. I made an application for modification of the decree before the City Civil Court. After the DRT was constituted, the application and all the proceedings were sent to DRT. DRT, my lord, says I can't go behind the decree.
Hmm.
I file a writ petition for that. From 1999, I have been having a stay right up to the time when the writ petition came to be dismissed on the ground of alternate remedy. And now before your lordships also, my lord, I have no action is taken by the bank against the principal debtor. I am just, they are flogging a dead horse.
What is this? Who appears with the bank?
I am for the respondent number 1 bank.
What
That
is
is
stating
for the
that-
bank mission.
Have you not taken any steps against D1 to D3?
The borrowers are not available. Only thing is this is the man available. That's the problem.
He has not consented to a decree.
Yes, madam.
Prove that he has not consented to the decree. If that is correct, how can a consent decree operate as against him?
The problem is that since there was a stay given by the civil court.
Yes.
It is a consent decree. A person who does not consent is not.
My lord,
a-
just look at annexure C at page 59, my lord.
Whether
Just a
the
moment.
appellant consented or not.
I have a problem with my.
We understand. So D4, if he is not consented. as a-
58, 59.
As on today, there is no decree as against him. If there is.
The
no-
office only says decree.
If there is no decree as against D4, you cannot proceed against D4. Proceed against the others. Nothing stands in the way.
Not consenting.
Or you must secure a decree if, as a matter of fact, you have a claim against D4, which is not time barred.
Kindly,
Against it.
post it for next week. Before that, I will have my hearing aid and then.
Well, that is something we cannot decline.
Just have a look at, my lord, your lordships may satisfy. Just have a look at page 58 for a minute, my lord.
Yes,
Just 58 is the order sheet.
yes.
29/1/20/1994, defendant present, D1 and D2, they are the principal debtors.
Yes.
And please look at the memo for consent at 59. Next page, my lord. Defendants 1 and 2 submits that he is very much present before the court and concedes to the payment of amount so and so commencing. This court may be pleased to pass decree accordingly. Half court, sorry, madam.
Yes.
Sorry. Defendants 1 and 2. I am 3. And then please look at 61. Page 60 is the typed copy of the decree. This is where the mistake has come. 60 at 61.
Yes.
Just have a look at 61.
Defendants.
Just to remove that one appendage, I have spent 30 years, my lord. 30 years.
But at least the decree has not been enforced as against you.
No, that is true. The courts have been indulgent because they also see that it's a mistake, but it's just that.
Fortunate in that regard.
Yes, my lord, yes. So whether he has a hearing aid or not, my lord, I have been heard by the courts. That
I
much
will
I can
make
say.
a submission. There was no consent on the part of the bank. Because on that day, he was all the time he was not attending at all. And then on that day, the defendants 1 and 2 appeared.
Yes.
And they said that we are ready and they wanted for some installments, etc. That was paid. And we were never a party to that consent at all. Question of consent does not arise at all. Even the memo does not say it. So there was no consent at all at any point of time, and it was not a consent decree.
Defendant concedes suit claim.
Concedes to the
Defendant
paper.
consent, not
Defendant concedes suit claim.
he concedes, but I am not a party to it.
What do you mean? This is your suit.
No, no,
Your
my
suit.
suit was there. Their contention is that without hearing the guarantor, both the plaintiff and the defendant, they have colluded together, is what they say.
There is a decree. And the decree, even according to you, D3 is untraceable at the time when the decree is passed, not served.
No,
He's not there.
let us make my point very clear.
Hmm.
After this civil court procedure was over, it was transferred to the debt recovery tribunal. When it was transferred to debt recovery tribunal, summons were issued. And then for the first time, he was placed ex parte because did not appear. Then again, he filed a miscellaneous application and then asking for setting aside. That was allowed. It was set aside. Then he was allowed to file objection statement before the DRT. Before the DRT, objection statement was filed. Then evidence was taken both the sides, affidavit of evidence. Then the DRT has passed a conclusive order. So all principles of natural justice have been.
Which is the conclusive order passed by the DRT?
Yeah, I will read it, madam.
Page 49, my lord. Annexure A.
Decreed against all defendants.
Yeah, annexure A at page 43. That is the order. There exactly, the Honorable Presiding Officer at page 45.
Consider the present.
45. There they say, the said suit came to be decreed against all the defendants on 29/1/1994 by the City Civil Court, Bangalore.
Against which he comes before this court.
At page 45, my lord, where the records further in that is, I think, 6th or 7th line, the records further indicate that by virtue of the said decree in the light of enactment of.
Not on the top of the
RDB
page,
Act.
they say decreed against all defendants. That is where the mistake comes. Top of 45. First line of 45.
Kindly wait, sir.
Correct.
I will finish mine. Then you have got your right.
It's my appeal, sir.
Please.
It is my appeal.
I am not able to clarify the position. Please excuse me.
Yes, please.
My lord,
The
can I also
record
come
further-
personally at
I will get-
2:30, my lord?
Not allowing me to read the
Not today. Not today. We'll have this on some other day.
Very well.
Because today in the afternoon, we have another combination.
Yeah,
May
yeah.
not be possible today. And that contention may not be.
No, my only subject.
DRT, no, we are,
Yes.
the issue whether DRT has not been issued with notice and no orders are being passed against the DRT. It does not matter whether they are on the party area or not.
No, I'm not talking. DRT cannot be arrayed as a party to the proceedings. That's it. That's it.
Yes.
Lord, the stay may be extended, my lord.
No, Miller, only one small issue which I want to say is that this is simple thing. All principles of natural justice has been followed and he has been provided with everything.
Consider.
31(2) of the DRT Act clearly provides that one and accordingly.
Stay may be extended, my lord.
Yes.
We'll
Mr.
examine the
Moderator,
DRT
may-
judgment.
Fourth, 31.
My lord, your lordship may have it any day after 10th, my lord. I am not available till 10th. Any day after 10th, please.
After 10th.
16th.
16th, fine. My lord, would your lordship extend the stay, my lord?
Of course.
I've had the benefit, please.
31.
Lord, I appear for the appellant, please.
Yes.
Lord, I'm aggrieved by, my lord, a portion of the order of the learned single
Same for
judge.
respondent.
My lord, the your lordship comes, my lord, page 17, the order starts. It's the,
Discuss on, please give
Lord,
a
after
date.
20th of April, I have a marriage function. I'll be out of station.
23rd, 23, 4. 32, Girish Arbudiyar.
please, wait.
When-
Millards, I was
Waiting
supposed to take a passover at 2:30, Millards, but just now your lordships expressed that.
30, we have other combinations.
Please,
Both of us have.
please, please.
Please give a date.
9,
Please,
4.
please, grateful. Minutes.
Number one, orders. Party in person, Syed Mohiddin.
This is a review petition. A review petition. Hmm. What is the delay? How much is the delay?
56 days.
756. What remains, Mr. Moore? What remains in this matter? Please tell us. It's not the issue. You've paid the amount, the matter stands closed now. Correct?
Excess they have paid, all.
Correct.
I have paying honestly, keeping paid over.
That is right. This is on 3rd September 2022. It stands closed. Correct? Sorry?
We are not satisfied. We are going to challenge to have given, we have issued a letter.
But they did accept the amount. PS value was 22.10. That was first accepted. Was again reduced by mention. What he has paid. Yes. Annexure? Settlement was initially offered at 30 lakhs. And that was down to 22. Then 21 lakh and 95%. Can you please talk into the mic?
Initially, they said, we are not interested. Then I too also waiting for their further response in this regard. Because in spite of my total payment and regular payment as an borrower, I myself have approached to the High Court that I wanted to settle in both the cases, in the WP as well as in the WA also. I have submitted a DD which was not, means little bit to overlook. It's a unfortunate slip.
slip during the division bench observation while delivering it. It is a most unfortunate slip that in spite of my all efforts, DD has been made and it is presented to them. But in spite of that, I don't know how it is slipped in while making a in part division, imposing the interest part.
Applicable interest on the amount of 21.0. Now everything stands paid. We
Yeah,
have
madam.
settled the
So, thing is, madam,
interest also has been
no, my
paid.
lord, there are two different payments. One, what they have committed into the return, that I have paid. But unfortunately, something has happened while delivering this division bench order. Their observation was that there is no records, bona fide efforts by the appellant that he is going to settle with the bank. There are more than 8 letters, 1 DD. After the judgment of the WP, it is lying, and till the order of the division bench, it was there.
I understand. Just a moment, please tell us, what is the amount that you have now paid to the bank? Is it 21.05 lakhs or have you paid the interest also?
No, madam. No, my lord. There are 2 payments for there. Suddenly I got some 10 lakh rupees difference. Then I was so disturbed. Then I borrowed, but they came into my house and they telling that within 14 days, we are going to auction your house. Like that, they have told.
Yes.
So that was only the reason this was delayed. Even as a party and person, I am not aware that further this RP is allowed. Somebody has told, no, you have to go to the higher courts or something like that. So afterwards, somebody has guided me, no, still there is a provision. That's why this delay has happened, madam. My lord, this is delay has happened. Since 14 years, I am suffering. I gave all my earnings to the bank. In spite of that, still their harassment and their huge problem is there. That's
Your
why.
document has now been returned to you. Your documents have now been returned to you.
Yes, I have received, because honestly, I gave, and I have full faith today or tomorrow, one day. The judiciary is there, the court is there, definitely they will do the justice. Based on that, I have made the payment by borrowing, taking some personal loan, some hand loan, all these things. The 10 lakh excess I have paid, my lord, sorry. So this delay may please be considered.
Yes.
Even a similar case is there, the Supreme Court has favored already that if you have collected.
Yes.
Even Supreme Court has favored in 24 one case, if you have collected excess money, then by with interest, you have to return the mistake or something is happened that you
It
have.
is not excess, it is according to the judgment of the division bench. Division bench said that the interest can be calculated. It's only
Please allow
according,
me.
because from 22, what the amount they had sought was, initially they said the OTS was 30 lakhs. Then it was brought down to 22.10.
Yeah, it is by them.
Even,
Yes.
correct, even that was not demanded. What the division bench ordered was only 21.05 lakhs.
Yes.
However, with interest.
No, but again, interest also.
Correct.
Calculate.
That interest is
Yeah.
not excess payment, but it is as directed by the division bench. Accordingly, appellant bank is directed to calculate the applicable interest on the amount of 21.05 and inform respondent about the total amount to be paid.
Yeah, the thing is, my lord,
Hmm.
the thing is, they themselves have offered because they made huge mistakes. And there was a confidential note from the Prime Minister's office to the Chief General Manager. They have appointed a DGM level officer, and he inquired and he said, no, there is some irregularities they have committed in written. That also, it is there in the file. If you want, I will tell the page number is, in fact, this is 1 minute. Yeah. Page 60.
Yes.
Page, sorry, page, annexure E, page number 70, annexure E.
Yes.
See, RAPC Banaswadi, we note to rectify the mistakes, if any, within 7 days, and also remove the NPA tag after rectification. We regret for the delay addressing this issue. They themselves have accepted, madam, my lord.
Well, that is over now.
Yes. But according to their,
It is only with regard to the interest payment.
No.
Whether it can be considered in a review petition is the only question. According to us, it cannot be.
no, the thing is, they themselves have told this much you paid, I paid. Then again, they retracted from their own written statement that no, like that. But in review, it has happened because in WP, it was very much totally inquired and delivered the decision or judgment. But here, what will happen? The order, if you want, I will read out. I will read out, madam. Please. Page number 22.
Yes.
Point number 7, Learned Counsel for the appellant submits that the letter dated 12/12/2018 was not addressed to the respondent herein, and there they cannot seek implementation of the same. He submits that the letter was, which was issued to the union minister, but it in the letter also, just I will show you that letter, what it is. It is clearly written into that, that you contact the AGM asset management recovery something. It is written, my lord. Page number, yes, 71, 71E.
Yes.
Page number 71E. They themselves have committed that you have to pay this much. And as a act of contract, the communication is over. The acceptance of both the sides is over. Even the token commitment of 1,500,000 rupees is also over. After that, they retracted from their own written commitment, and by force, I opposed to the High Court with the WP and requested that these directions may please be issued, and they have issued.
Yes. We'll take this for orders. We'll take this for orders. Pass orders.
But I am allowed for further RP.
Is reserved. Reserved for orders. This is your contention. You have given everything here. We'll look into it. Reserved. Please tell him what it means.